Islamabad, former Prime Minister Nawaz Sharif has prayed to the Supreme Court to set aside the order passed by a top judge in his chamber, on his appeal against Registrar Office, seeking to club together 3 National Accountability Bureau references against him, and fix his petition before a bench for hearing. On October the 18th, the former Prime Minister filed a petition in the Apex Court under Article 184(3) of Constitution against the July 28 judgment in the Panama Leaks case, under which he had contended, per incuriam, with no due regard to the law or the facts, the National Accountability Bureau had been directed to file the 3 references against him. On November 20th, the Registrar Office returned the petition with the objections that the petitioner had already availed all the remedy against the July 28 judgment and the petition was not maintainable under Article 184(3) of the Constitution. Later, Sharif had filed an appeal against the Registrar Office objections stating that his petition did not form part of the grounds of attack in the review against the July 28 judgment. The ex-premier had explained that under Article 184(3), he has remedy to assail the judgment on the rule of per incuriam. On November 16th, Chief Justice Saqib Nisar, who had heard the appeal against the Registrar Office objections in his chamber, dismissed his appeal and ruled that Sharif should have mentioned the grounds in the review petition. In his constitutional petitioner filed on Saturday, Sharif said that the impugned order suffered from errors of law floating on the surface of the record and was tantamount to denying him of his fundamental rights enshrined in the Constitution. The ex-Prime Minister has filed the petition under Article 184(3) of Constitution and made the Federation through the Ministry of Law and Justice, the NAB, Accountability Court, Hussein Nawaz, Maryam Nawaz and Capt. Retired, Muhammad Safdar as respondents. He has contended that the impugned order forces him to face rigor of multiple prosecutions for a single offense, which is tantamount to violation of his fundamental rights under Article 10-A of Constitution, and the impugned order exposes him to triple jeopardy in contravention of his fundamental rights under Article 13. It is also violative of the petitioner's rights under Article 9, 14 and 25 of the Constitution, he said. Sharif said that there was the Supreme Court's own judgment in Judges, Pension Case and Nahib Butt vs. State, and the petition under Article 184(3) is maintainable after the dismissal of the review petition and the question of law is referred to a larger bench for a decision. He has contended that in Petition No-86 of 2010, the order passed on March 7, 2017 by the court has already referred to the question, as to whether after the dismissal of his review petition, an aggrieved person can seek further remedy in terms of Article 184(3), read with Article 187 of the Constitution for a consideration by a larger bench. He said that since his case was identically placed, therefore, the top judge in the chamber ought to have treated his constitution petition in the same manner, following the principle of equality, due process, and should have set aside the registrar order.